Here is another court opinion from the 11th Circuit, which again is not my circuit, but it might be where this wonderful share of analysis is sitting, and that would be Attorney Adriana De La Torre. And I want to share this. I love to share her stuff because she does such a fantastic job summing it all up for us. Way better than most of us could do for ourselves. So here we go. And as I state in other videos, it's 11th Circuit. It doesn't officially apply to everyone all over the country, wherever their Social Security case is. However, these principles often do apply otherwise anyway. It just happens to be that they're being emphasized here for a particular case and a particular highlighting of an issue, and it happens to be in the 11th Circuit. But also, I think it's often true that other circuits, all trying to do the right recognition for Social Security law and intent, will take to heart, and I'm sure they study other circuits' opinions to see if that's the way they're going to go to. So, unless it's already defined in their circuit, I think what can be logical in one may very well apply and be useful elsewhere as a practice for a claimant to take heed to. Okay. So in this case, this was, I don't know if I'm going to say it right, ARCE versus the commissioner, ARCE being ARCE. This is also January of 2024, very recent. So a Ms. Arce appealed the denial of her disability claim. And this is generally how we get to be in federal court, right? There's a denial by the ALJ. The appeals council didn't decide to do anything in favor of the claimant with it. And the next appeal is up to the federal court system. So this is where Yvette was. She appealed her disability claim. And she was claiming that the ALJ had erred when he was assessing her residual functional capacity. Now, we've talked about RFC, residual functional capacity, and where that comes into play. And I'll see if I can't put a button at the end about that. And she says it's because he did not consider her non-severe mental limitations. Now, for those of you that might be unaware, even the regulations say that severe and non-severe impairments must be considered. MDIs are medically determinable impairments. Those are the ones that have to be considered, whether they are severe or non-severe. Okay. And when we say medically determinable, that means they have been determined within the medical records to be actual impairments, an appropriate diagnosis, as opposed to an allegation by a claimant or a suspicion, even a mere suspicion by a medical doctor, but the full diagnosis hasn't yet been made. Maybe the tests haven't been done, might not count at that time. Which, as an aside, if your doctor does have a suspicion about something and he's trying to rule it out or rule out other things so we can rule that in, that is something that you're going to want to aggressively pursue so that by the time you get to whether it's you're going to be filing or you're already filed, but you're in adjudication and you don't have that diagnosis yet, you want to make sure you stay on top of that, because if you end up going to hearing, you're going to want that to be a diagnosis by the time you get there. If you're going to hearing, it means that your medical evidence wasn't strong enough prior thereto, right? On initial and reconsideration. Okay, moving forward. Okay, so the analysis here goes on to say, the 11th Circuit had stated that when determining RFC, of course, the ALJ must consider all of the claimant's medically determinable impairments, including those that are not severe. This is what we just talked about. So this is mainly a drive home point about that. And here's the kicker, because I've seen this before. Although the ALJ, and this is what Arce was arguing, although the ALJ here said that she'd considered all of Arce's symptoms, including the non-severe mental impairments, because they put that language in their decisions regardless, the content of the ALJ's decision with respect to the RFC only indicated consideration of Arce's physical limitations. So I think it's important if you have an ALJ denial, and we have a section on kind of certain things you can look for in your ALJ decision and see if it's there or not or how it's presented. And I do believe that one of the earlier ones we did was when you look at the section where the ALJ describes all the impairments, you want to make sure that all your diagnoses are in there. Yes, it's true that the ALJ may find that some of those impairments are non-severe versus severe, but he still has to consider them because even non-severe impairments can have a little bit of limitation attached to them. If you have a non-severe pinky thing where it's a little stiff, you can't, you're not quite as agile with it. That could be a non-severe limitation, but it might prevent being a surgeon. You see what I'm saying? Remember, we're trying to carve out those 12,000 jobs. So even those non-severe impairments that don't affect a lot in life could affect certain jobs. Okay, moving on. The circuit court agreed with Ms. Arce, and they vacated the SSA's ultimate decision via the ALJ and remanded the case for a more detailed evaluation of how these mental limitations affect Arce's ability to work. And of course, as Adriana astutely points out, this case underscores the significance of thoroughly assessing all impairments in the RFC, including non-severe mental limitations. So I'm going to try to link that video about, look at the end for a button, about that paragraph you should be looking at in your ALJ denial when you're like, should I appeal this to the appeals council or should I just try to file again if I'm even able to? It's one of the things that's going to, drive home what impairments were considered impairments, and non-severe ones have to be considered, even though they might not be severe and disabling in and of themselves. Okay. That's a big one. Big, big, big. Okay. And that, of course, that whole rule about assessing non-severe impairments as well is in the regulations. So this is going to, the fact that it's in the regulations and has to be done is universal then, I would say, in all parts of the country. So it's even more robust an area than only the 11th Circuit that this case came from. Okay. All right, guys. Thank you, Adriana. You are fabulous as always. And I'm a little bit behind on these to share them to you guys, but I will get there. All right. Bye.